Guys, we have Drew Findling's response to the prosecutor's motion to keep Durk in jail. And I'm happy to see this. They got an extension to be able to work on this and respond to the prosecutor's motion, which we read through in my other videos, and it was very thorough. It was very intelligent. It was very well written. And let me reiterate, these are government attorneys, assistant U.S. attorneys, probably very experienced attorneys. On the other hand, we have Drew Findling right here. Drew Findling, who is part of the Findling law firm, his own law firm. Then we have Marissa Goldberg. These are both Georgia barred attorneys. And she also works under, I guess, Drew Findling, or she might be a partner or something like that. And then you have another attorney from Chicago. Okay, you have Jonathan M. Brayman. I guess because this case is related to Chicago, and maybe he has more experience with how these gangs work and how to put up a good defense. And then you have, of course, a Los Angeles, California attorney, and that is Christy O'Connor, who's California barred. And these are the attorneys for Durk Banks, aka Lil Durk. And this is their response. Let's read through it. I don't want to say too much. Let's read it, and let's read it together, and let's see how we feel about it. Let's measure its strength. You can watch my other videos to look at the prosecutor, what the prosecutor had to argue. Now let's see what this what do they call him? The $1 billion lawyer. Let's see this $1 billion worth of work. Let's see a $1 billion response. Let's see this $1 billion worth of experience. All right, let's get started. This is the Memorandum of Points and Authorities. On December 12, 2024, this court held a detention hearing and ultimately ordered that Mr. Banks be detained based on two factors, which we discussed before. These are the main factors the court considers: danger and flight risk. Okay? On the issue of danger, the court relied primarily on the facts presented in the first superseding indictment. The issue of flight risk, this court admitted, was a closer call. As the court is aware, the probation department assessed that Mr. Banks was not a flight risk, but did recommend detention based on dangerousness. Okay, so the probation department does not think Mr. Banks is a flight risk. Okay, for some reason they think he's already been caught. If he's looking to flee, he could have fled a long time ago. Why did he wait? Right? But you guys know he did book multiple flights, even though he never got on any of them. He did book multiple flights, some of them to places that does not have an extradition treaty with the United States. Okay, let's get into paragraph 2. Since that hearing, the landscape has shifted. On May 1st, 2025, the government filed a second superseding indictment, which removed two major allegations from this first superseding indictment. First, it removed the allegation that Mr. Banks' song lyrics somehow glorified the murder of SR. And second, it removed the allegation that Mr. Banks directed others to pay or be paid a bounty for the murder. Okay. So they've removed the allegation that Lil Durk directed others to pay or be paid a bounty for the murder. Okay. So how is it a murder for hire without that? Interesting. Maybe that's why they brought in that third charge that we talked about, stalking leading to death. All right. Maybe they feel they can prove that much easier than that Mr. Banks directed others to pay or be paid a bounty for the murder. And another thing, one thing they could always argue, and one thing that I think happened, is literally that these dudes may have taken the initiative upon themselves. I don't necessarily think that Banks had to direct them. Maybe they feel, oh, this is the big rapper, and maybe they give him information like, hey, this is how it's going down today, so on and so forth. So that is something that can be presented as a defense. Let's read on. Importantly, the government returned to the grand jury and sought the second superseding indictment after, and apparently in response to Mr. Banks filing his motion to dismiss the indictment and his application for reconsideration of the detention order. In essence, the government effectively conceded Mr. Banks' central argument in his application for reconsideration, that the government presented false and or misleading information about Mr. Banks to the grand jury and to this court concerning critical factual allegations. Okay. In its response and supplemental filing, the government downplays these charges as immaterial and undeserving of this court's consideration. However, as detailed below, they are both appropriate and of great import in this court's review of the statutory factors for release. With the issues of the lyrics and the payout of a bounty altogether abandoned, what remains of the indictment is a weak patchwork of unsupported and non-specific allegations against Mr. Banks. This watered-down new indictment, coupled with the robust bond package proposed here, tips the balance in favor of Mr. Banks' release pending trial. Okay, they're saying that there isn't so much. It's a watered-down patchwork of unsupported and non-specific allegations against Mr. Banks, which we noted. We suggested that maybe they were putting in this stalking leading to a death as a sort of safety net because they didn't feel that what they had, the murder for hire charges and all that, was as strong as they thought. You know, and we said that on the internet. You can look back at my videos. I said that before. A lot of people were saying, oh my God, the prosecutors are coming hard. They got such a strong case. But I analyzed it for you guys. And I showed like, hey, why would they be using this safety net? You know, why would they be using the safety net? And that's because they had to remove some of those charges, the payout of a bounty and so on and so forth. And so those aren't charges, sorry, but those allegations, they had to remove some of those allegations which they could have used to create that connection and meet those elements required for a murder for hire conviction. So that's interesting, all right? Let's read the argument. This gets a little bit legal maybe, but let's read it. The weight of evidence has changed since the initial detention order. 18 United States Code Section 3142G2 requires that the court look at the weight of the evidence against a person to determine whether there are conditions of release that will reasonably assure the appearance of the person as required and the safety of any other person in the community. With the new indictment in mind, the alleged weight of the evidence against Mr. Banks is significantly weaker. Okay, so what it's saying is the court has to look at the weight of the evidence against the person to determine whether there are conditions of release that will reasonably assure the appearance of the person as required. Okay, I don't know if that's an interesting connection there. I don't know about that argument. That doesn't seem to make absolute sense, because why would they have to look at the weight of the evidence against a person? Oh, okay, the weight of the evidence against the person. There are conditions of release that will reasonably assure the appearance of the person as required. Okay, all right. Yeah, so what? That doesn't say much. First, the second super indeed remove paragraph. But see, this is where they're trying to confuse the judge. They're trying to play the game. They're doing their lawyer tricks, all right? Because right here, they're referring to the weight of the evidence against a person to determine whether there are conditions of release. They're not talking about the weight of the evidence against the person in general as to his charges, but as to the conditions of release. But in the next paragraph, the first thing they address is his actual charges. Let's read it. First, the second superseding indictment removed paragraph 6 of the introductory allegations in the first superseding indictment, which relied on lyrics from a song to allege that Mr. Banks was somehow celebrating or commercially glorifying the death of SR. This was a hotly contested issue at the detention hearing with the second superseding... Okay. So he's saying this is a hotly contested issue at the detention hearing. But in the brief presented by the prosecutors, they quoted the judge as saying that he didn't give that much weight. Okay, so they're playing lawyer tricks. Are they trying to sound good for the fucking public? Are they trying to sound good for Lil Durk? Because if the lawyer has previously stated, the judge previously stated that he's not putting so much weight to this issue, what the fuck are you guys talking about? Now let's continue. With the second superseding indictment, the government has now conceded the issue entirely, despite the fact that it took up a significant portion of the detention hearing. To be clear, the inclusion of the now removed portion referencing song lyrics was more than immaterial fluff in the first superseding indictment. The government absolutely intended that section to illustrate direct involvement in the alleged murder for hire, and more importantly, the knowledge of Mr. Banks of the alleged offense through some sort of musical confession. Okay. The government has now been proven wrong and has removed the reference, substantially depreciating the weight of the allegations. Okay. Of equal or even greater import, the second superseding indictment removed paragraph 9 of the original indictment, which alleged that Mr. Banks directed others to pay a bounty for the killing of SR. Now that's a big deal. All right. That is a big deal. The prosecutor has removed the allegation that Mr. Banks directed others to pay a bounty for the killing of SR. That he told the other dudes who got those dudes from Chicago to come into LA to commit this homicide. He did not direct those dudes to pay those dudes a bounty. All right, so that's interesting. That's interesting. They removed that allegation. I guess they can't prove it. They can't prove it. They cannot present any evidence that would show that in court, so they removed it. They removed it, guys. That's a big deal. What was I telling you guys? The case is not as strong as Trapfloor Ross or Poetik Flakko or any of these people on YouTube are making it out to be. What did I tell you guys, bro? Why would they do endless superseding indictments? Now we know that they've removed multiple allegations and they created a safety net in that stalking leading to death charge that they brought on Lil Durk and his defendants. Let's continue. This material change also significantly impacts the court's calculation, as this court in the initial detention hearing specifically cited the government's allegation that Banks exercised control of others and that other people acted at his direction to find dangerousness. Okay, so the court's calculation, as this court in the initial detention hearing specifically cited the government's allegation. Okay, so they're saying that the court believes that Banks exercised control of others and that other people acted at his discretion, and through that they found dangerousness. Now they're saying, since Mr. Banks did not direct others to pay a bounty for the killing, he does not actually have the level of control of others previously alleged. Here we go. This is the big money lawyer work, man. This is pretty good. And now. Okay, here it is. They're quoting the judge. Let's see. Although the allegations are not that the defendant personally pulled the trigger, the allegations are that the defendant exercised a significant amount of control over other individuals and that those individuals were acting at his direction. Now, with the payment of the bounty allegation withdrawn from the indictment, the foundation for this court's conclusion has been materially undercut. Gunshot. All right, that's pretty good. All right, they're saying, look, you relied on this to say that he had control. The allegation is that he has control. But now the prosecutors have removed the allegation that shows that he had control of others. So what could you be relying on? If the prosecutors themselves remove this allegation. Gunshots, all right? Outside of the allegations in the new indictment, the government can only point to ambiguous and insubstantial pieces of evidence, one singular text message subject to a variety of interpretations alleged to have been sent by Mr. Banks. Okay, and that's the one regarding the credit card. Hey, please don't use my credit card or whatever he told them dudes. Man, what did I tell you guys? They don't have much. I told you guys they don't have much, bruh. I told you guys they don't have much, man. I knew it from the beginning. In the comments, I was out there. I said they don't have as much as you guys are making it out to be, bruh. Free Lil Durk. All right, let's go on. No other specific or direct, and I've never been a Lil Durk fan. All right, guys, I've never listened to his music like that. So I knew from the jump, bruh, what the fuck are they putting out there? Oh, he sent a text message, and he was in town on the same day. Oh yeah, whatever, bro. I could tell anyone. You tell your friend, hey, please don't use my debit card, bro. I know I left it with you. And then they go around and then commit a homicide and they use it's just, they have no, that's not enough. You don't convict people on that, man, especially with these big ass charges. Let's keep going. No other specific or direct evidence has been provided to date. Has been provided to date, including any evidence showing Mr. Banks' alleged control of others, the government continually refers to in the previous indictments and in their arguments before this court. Get rid of that, Judge, is what they're saying. If the prosecutor is not alleging that anymore, how can you rely on that? How can you rely on that, Judge? The bulk of the government's contentions include its own proffered generalizations that seemingly come from an informant whose veracity and credibility has never been subject to challenge, to support the false notion that Mr. Banks is or ever has been a danger. What was I saying, guys? What was I saying? These witnesses, if you have a criminal with a criminal record, what kind of witness is that, bro? Everyone would try to throw Lil Durk under the bus. He's the rich one. He's the one that they want. He's the big fish that they want to fry. So of course I can throw him under the car, you know. I can throw him under the bus, and I can save myself, right? I can save myself. I'll give them Lil Durk, Mr. Banks. I'll give them whatever they want, you know. And I'll give them, and I'll build a case for them, and I'll testify, and I'll give them false evidence and everything. That's why you have to question the credibility of these witnesses, because like I told you guys, in a bond hearing, it's not the same rules of evidence. It's not the same rules of evidence. They're not bringing up witnesses that have to follow the rules of evidence, be cross-examined, direct examination, all that stuff. You don't have to follow those rules, man. No hearsay, no none of that. And so there's not a jury to assess the credibility, nor is there a judge right there sitting there to assess the credibility of the witness, because the witness isn't there. So they're relying on information from someone whose credibility hasn't even been assessed. Guys, there's no case. All right, let's keep going. While it is true that the second superseding indictment also added an additional charge of stalking, the addition is immaterial to the question of detention, as the allegation already existed in the superseding indictment. Interesting. No new allegations are contained in the stalking charge of the second super. Okay, so there's a charge. There's a charge, but there's no new allegations under that charge. They're trying to prove that charge using the same allegations they previously used. So there's nothing new that came out of that charge, except it's a new charge. It's certainly trouble that they have to fight. But they're using the same underlying allegations to bring that charge. Let's keep going, guys. This is fucking fire, man. This is the good shit. Thank you, Drew Findling. This is the good shit, man. And their law firm, whoever worked on this, big ups to you guys. Reasonable conditions exist to secure the safety of the community and to assuage any concern regarding risk of flight. Look at these fancy pricks. All right, they probably used some AI shit for all these fancy words. Let's keep going. Mr. Banks has filed a robust bond package which outline a variety of conditions to secure the safety of the community and ensure that Mr. Banks complies with all the conditions imposed by this court. One of the conditions that Mr. Banks proposed was the use of a 24/7 licensed security company. This court expressed concern that the presence of a security company providing security for the defendant is not going to address the significant concerns with regard to the safety of the community here, because the security company would be acting at the direction and under the guidance of the defendant. All right. So they're saying basically, look, you can hire a safety company, but that's to your benefit. What about the community? They're not hired to secure the community. They're hired to secure you, and you're the one who pays them. So how does that benefit the community? The government argued that the security would be present for the physical protection of Mr. Banks. Okay, to clarify, the purpose of the security company, detailed in the bond package, would be to enforce the terms and conditions of the bond set by this court. Specifically, if there is an order regarding curfew or home confinement, the security company would serve as a prophylactic measure to ensure Mr. Banks' compliance with those conditions. Put another way, the security company would be beholden to this court. No. Shitty argument. Shitty argument, not believable, not believable, not believable. Mr. Banks is paying. They don't give a fuck about the court. Mr. Banks is paying. Security is definitely vulnerable. You can bribe them. You can do all sorts of shit. You can maneuver. Maybe you know these security before. Maybe you've used them. Maybe it's one of the homeboys. Maybe he's a GD or BD and all that crap. So no, 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 no. Bullshit argument. Both Mr. Banks and the security company are well aware of this agreement and will provide a specific plan regarding the line of communication to the court and or pretrial services if the court allows release. With this check in place, Mr. Banks poses no danger to the community or fleeing the jurisdiction, as non-compliance would trigger the immediate alert of the court. Okay. Not really great. Not really great. He's still dangerous. That's not good enough. A judge is not going to believe that unless he's a monkey-brained. The other arguments are pretty good. This is not good enough. Conclusion. Wherefore, based on the change of circumstances created by the second superseding indictment, as well as the significant bond package that includes stringent conditions that will properly rebut the presumption that he is a danger of flight to or a flight risk, Mr. Banks respectfully requests this court release him on conditions pending trial. All right, guys. They didn't have much, it seems, for this argument. The safety of the community with the security argument. Man, that shit's weak, man. As if we've seen these security guards, right? They're doing freaking interviews. You got Gene Deal. You got that other dude on Vlad. Then you got that fat dude, CC something, whatever. You've seen these interviews, guys. These security guys aren't to be trusted. They're trying to get laid. They're trying to get paid. They're trying to get involved. They're all sorts of shit. So these security companies are not to be trusted, nor the type of people they hire to do security. You know, it's not like they're all ex-FBI agents or something, or ex-police officers. Ain't even that. Doesn't prove much. You know, it doesn't prove they're going to maintain their integrity and protect the community or hold up to agreement, especially when it's Lil Durk who's paying them. You know, they're prone to bribery and shit like that. And so I don't think the judge is going to believe that second argument. All right. And truly, there is a danger to the community, man. You're telling me Lil Durk is going to get out and he's not going to try to do anything in his power to try to fuck up whatever case the prosecutors have? But that's his job. But no, I don't mean legally. Like, he might deal with witnesses. He might put out a statement, a tweet, or anything that could, you know, put the witnesses in danger or whatever. And so I don't think the judge is going to go for that part. All right, that part is not great. I guess they don't have much else. You know, I mean, we could brainstorm together what else they could put there instead. You know, but the first part of the argument, incredible, man, incredible. They really just said something very straightforward. Hey, look. These allegations on which you relied on previously, court, judge, you relied on these allegations previously to say that he had control. But now they've removed those control elements. All right? Even if you didn't care so much, because I know that in the previous motion by the prosecutors, they quoted the judge as saying that he didn't really put too much weight as this to this issue of when did the lyrics come out, are the lyrics real, all that stuff. He didn't put too much weight to that. But he did put weight to the fact that, you know, he these allegations that he has control of people, But now in these superseding indictments, the prosecutors have removed those allegations, removed one of those fundamental allegations, which is that he told his dudes to pay a bounty to anyone who would kill these guys, you know? And they brought these guys in from Chicago to kill these guys, and they were going to pay them, or they were going to give them a deal, music record deal, whatever, all that bullshit. And so the prosecutors have removed that allegation, guys. They've removed that allegation. And so the Drew Findling, his law firm, are arguing, hey, the allegation's not there anymore, and you relied on that previously to say he was dangerous. All right? You relied on that previously. We've also proven he's not a flight risk, okay? They didn't really address the flight risk issue very well, did they? Because I guess they don't have much. The best thing they have is that the probation department assessed that Mr. Banks was not a flight risk. Okay? But did recommend detention based on dangerousness. So this is what they're relying on. They're saying that, hey, the probation department said he wasn't a flight risk, but he did say he was dangerous. So let's argue this dangerousness issue, because we've already established he's not a flight risk. The probation department itself established he wasn't a flight risk. So let's just deal with this dangerousness issue. But frankly, guys, he bought multiple tickets to multiple destinations, some of which were non-extradition, which means that America does not have a deal with them to get any fugitive back from there to the United States. But that gets complicated, and they can figure out ways to get those people here. You know, it's not set in stone. It happens all the time. So that gets complicated. But hey, what do you guys think? You know, I told you guys, look at my previous videos. I told you, I don't know about these people, the videos they're making. It's really shock value. Poetik Flakko, Trap Lil Ross. I don't think they understand what they're talking about. Especially Trap Lil Ross, and I mean both of them. And Vlad, they're all just, they hate Lil Durk or something, man. They're trying to make it out like, oh, this is for sure. And any allegation put against him must be, you know. They're not giving him, you know, the benefit of the doubt. They're not giving him that. You know, innocent until proven guilty. They're not giving him no doubt. He's not innocent in their mind. You know, and they're making out like the prosecutor has this immense case. And then they throw out this number. The federal government takes 92% of cases, does this, does that, you know. Wins 92% of cases, whatever. Man, that's all bullshit, bro. 92% of cases against people who don't have Lil Durk money. Against people who don't have like that much between them and the crime itself, you know. And they don't have much, man. They really don't. All right. That's why they had to do that safety net. And even under that safety net, there's no new allegations. They're just bringing a new charge of stalking leading to a death or whatever, using the same allegations, right? And so I detailed all that for you guys. Let me know what you think. It's a longer video. I hope you enjoy it. All right. I'm going to try to make a cool thumbnail because that's what makes people want to watch this stuff. So I'm going to try to make a cool thumbnail. I'm sorry about maybe the sound quality because I am using just headphones and not my usual mic because I'm not there. I don't have it available. But thank you guys for watching. Case continues. It's very interesting. What do you guys think? Is Drew Findling worth his money? I mean, the arguments are not exceptional, but they did their research and it's a fair argument, but they're not exceptional. We haven't seen the exceptional yet. Maybe the exceptional that makes him $1 billion lawyer maybe comes out in court, you know, which we will not get to witness because it's a federal court, so we don't get to watch the case. But maybe we'll see somewhere else that something exceptional comes to light. You know, at the end of the day, he's just a lawyer. And lawyers are what they are, all right? Thank you guys for watching. Like, comment, and subscribe. Let me know what you think. Peace.